No one should have their personal safety put at risk or have to feel uncomfortable while they're working. If you are dealing with a boss or coworker who refuses to end their harassment against you or others, then it's important to talk to an employment lawyer for help. What are the different types of sexual harassment? The Equal Employment Opportunity Commission separates sexual harassment into two categories labeled hostile work environment and quid pro quo. Hostile work environment sexual harassment occurs in any workplace where unwarranted physical, verbal, or emotional conduct is unavoidable and inhibits workers from doing their job. Quid pro quo sexual harassment means this for that. A common example would be an employer offering their employee a raise or promotion as a reward for performing sexual favors. More general examples include unwelcome visual, verbal, written, or physical sexual behavior, comments about clothing or a person's body, sexual-based jokes, sexual intimidation, inappropriate touching, kissing, or hugging, direct requests for sexual favors. Sexual harassment is a term used to describe unwelcome sexual behavior and speech that makes an individual uncomfortable in a sexual sense, regardless of whether the behavior comes from a man or a woman. It includes a variety of behaviors that are sometimes encountered on the job that have been determined to be discriminatory, coercive, and illegal. A number of specific actions fall under this category, and JacksonWhite sexual harassment lawyers in Mesa, Arizona, can inform you of the specific steps you should take to file a lawsuit. What constitutes sexual harassment in Arizona? Sexual harassment includes any request for sexual favors in exchange for consideration in hiring, promotion, or wage increase. It also includes constant sexual comments, threats, or unwanted touching that would constitute a hostile environment for the worker. A hostile environment would also include pornographic pictures, sexual jokes, or lewd remarks. These actions are in violation of Title VII of the Civil Rights Act of 1964, which is in effect for any company with 15 employees or more. You have 180 days from the harassment incident in which to file a complaint under Title VII. Harassment can be committed by supervisors, co-workers, company owners, clients, or vendors. Usually, sexual harassment is thought of in regard to men's treatment of women, but it can also involve women harassing men harassing men, or women harassing women in a sexual context. Arizona has its own laws regarding sexual harassment, but local laws may also apply and may include companies with fewer than 15 employees. Laws in Arizona regarding sexual harassment. In the state of Arizona, both federal and state sexual harassment laws may apply. Title 18 applies to companies over 15 employees, and the complaint is filed with the EEOC. If you work for a company that is smaller than 15 employees, state laws would still apply, and you would file a complaint with the Arizona Civil Rights Division. However, an attorney may advise you to file with either agency, depending on which statutes would best apply to your case. In Arizona, the sexual attention must be unwanted, which means that individuals must make it clear they do not want the attention. Both agencies have a 180-day statute of limitations on sexual harassment compliant cases. Steps for filing a sexual harassment complaint. To deal with sexual harassment in your employment situation, it is recommended that you first speak to the individual doing the behavior, informing them that it makes you feel uncomfortable and asking them to stop doing it. However, this action may be too threatening for the person, in which case a supervisor may be brought into the complaint. It is illegal for an employer to retaliate against an individual who files a sexual harassment complaint. Several steps can be taken to report a complaint of sexual harassment. Go to your supervisor and report the behavior, informing him or her of the steps you have taken to stop it. Read your employee manual on what you should do in cases of sexual harassment, a subject that is often covered in human resource materials. Keep records of the incidences of harassment, when they occurred, and what was said. If there are witnesses to the behavior, ask them to provide a signed statement. If the company is not willing or able to remedy the situation, file an Equal Opportunity Employment Commission complaint to help you to remedy the situation and come to a settlement. Filing an EEOC complaint is a legal requisite for a sexual harassment lawsuit in court. An employment law attorney can help protect your rights. Although you are not required to hire legal counsel for your sexual harassment complaint case, An attorney can give you with important information on how sexual harassment cases proceed and what information you will need to provide to make your most effective case. Generally, sexual harassment lawyers are paid on a contingency basis. That is, they take a portion of the financial settlement you will receive if your case is successful. You should be aware that sexual harassment lawsuits can be difficult to prove and can extend for a long period of time. Not all lawyers are willing to take a sexual harassment lawsuit, but if you have good evidence and witnesses to the actions, it will be easier to prove your case. Sexual harassment can cause extreme distress and can affect productivity on the job. If you are being harassed at work, talk to your human resources department about filing an official complaint to stop the behavior and allow you to continue being productive in your employment. Our employment lawyers in Mesa, Arizona are ready to help you prosecute your case. Call our employment law team at 480-526-5848 to discuss your case today.